Oh. Hey, I said, man, never know. So let them know we're waiting for who?
Mr. Liver?
Yes, sir.
Good morning, everyone. Welcome to the DC Court of Appeals. If you have a cell phone that's on, can you please turn off the cell phone for the oral argument begins? And you can mute or just turn the cell phone on. Thank you. Court will be starting in about 5 minutes. Here it is.
Nah. Yeah, she definitely about to be. She get nice.
Oh, I can. All rise. All persons having business before the Honorable Chief Judge and Associate Judge now presiding over the District of Columbia Court of Appeals draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated. Come to order.
Great. Good morning and welcome to the historic courthouse. We have two cases set for argument this morning. The third case was taken off the calendar. Chief Judge Adam Blackburn-Rigsby, and I'm joined by Associate Judge John Howard and Associate Judge BJ Schenker. Counsel in Stephen Sims versus United States, are you ready to proceed?
Yes, sir.
Thank you, Madam Chief Judge, and may it please the court. My name is Greg Lipper. I represent the appellant, Stephen Sims. I would like to reserve 4 minutes for rebuttal.
Good morning, Mr. Lipper. Can I start you off by asking, was there any testimony at the 23-110 hearing about any investigatory steps between the first trial and the second trial?
There was not. The most I think you could say, if I were to argue for the government for a moment, which I obviously am not, but if I were to argue, I would say that the most you could say was that trial counsel acknowledged that the written time records that he submitted as an exhibit did not include his investigators' work. So it is conceivable that, but there was certainly no testimony. And in fact, even when trial counsel was testifying about trips he had made to Saratoga Avenue, which at least arguably were not reflected in his time records, he never said, yeah, that was between the first and the second trial. So there was.
Can I ask you, where does the absence of evidence on this question take us? Because obviously your client had the burden to show deficiency in the trial court. There was evidence that showed efforts before the first trial. We're assuming now that there's an absence of evidence one way or the other between the two trials. So is that something your client failed to sort of elicit, or is it something that cuts against the government here?
I would actually say, I wouldn't actually characterize it as an absence of evidence so much as I would say, well, Mike, let me answer. I think it cuts against the government. And the reason why is that ultimately, human memory is human memory, right? And so I think it's fair to say that trial counsel wouldn't necessarily have been expected to remember precisely every step he took 11 years ago or 11 years before he testified. However, the written logs, the written contemporaneous logs, which were provided as an exhibit, and there was testimony on this, were designed by the trial counsel's organization to be a, recording of everything that was done. In other words, the practice was, I would, when you do something, you would then, when you got back to your office, you would log it. This didn't come up, but I imagine this is a sort of thing that gets documents admitted as business records, because it's like, it is our practice to, we come back to the office, we write down everything we did and so on. And so given that there is a contemporaneous record of what steps were taken and were in fact relied on by the trial court, which he said this reflects the efforts that trial counsel took. The absence of evidence is in this case actually evidence of absence, because the practice is when you do things, you write them down. And
with
so
the caveat being one that you already posited, which is that it could have been his investigator, because even the records that did exist did not capture the investigator's actions, right?
It theoretically could have been, but then I would say that trial counsel certainly didn't. He didn't have a perfect memory. He didn't have no memory. And trial counsel, although he was able to say, I recall doing X, Y, and Z, he did not identify any. He didn't say even generally, yes, I remember between the two trials, we went and walked down Saratoga Avenue, or I sent my investigator to go down the avenue. I mean, he didn't even have that sort of general range. Oh yeah, I recall that after the first trial, and remember, this is something that I think he would have thought about, because after the first trial, he testified that Sims was, very unhappy after the first trial because he had not been acquitted of either of these offenses, and he had been adamant from, close to day one that he needed to present these witnesses. And so in that circumstance, not only do we not have it in the written log, but we have no oral testimony about even that multi-month range, even when the time between the two trials would have been especially salient because A, it's a retrial, B, client is unhappy about the result in the first trial and the failure to provide the witnesses.
Well, counsel, how much should we balance that against the frustration of effort trying to track down these two witnesses, the grand jury testimony that could be characterized as confusing or imprecise? Like, could we not just talk it up to a strategic decision that the attorney had already made, even if we assumed that, there was no effort made during that 3-month period?
So that's actually, I guess where I was going to start, which is, there is not presenting someone to testify is one thing. Not subpoenaing them to the trial is another thing. Just to make clear what I think this has been implicit in all of our briefing, but defense counsel can subpoena witnesses and subpoenas witnesses ex parte, can subpoena whoever they want and doesn't have to call any of them to testify. It doesn't even have to tell the government who they subpoenaed.
Right, but the only benefit of subpoenaing them at that point would be the hope that you'd be able to meet with them for however brief a period in the court hallway before presenting them in a very serious criminal case. So the decision not to do that still strikes me as possibly strategic, right?
Well, but let me say two things in response to that. The first thing is that I think we know that there wasn't there couldn't have been a strategic decision just to cut bait, because at the very beginning of the trial, when the jury, the entire, the dozens of prospective jurors come into the courtroom, basically the first thing that counsel is asked to do on each side is introduce themselves, introduce their co-counsel, and tell the possible jurors who their potential witnesses are, and that's done so that the jurors can say, oh yeah, I play basketball with that guy, I can't be a juror. And trial counsel listed both Mr. Evans and Mr. Davis as potential defense witnesses at the beginning of trial. So he clearly hadn't written them off. He clearly hadn't drawn a big marker through them. And I think,
Doesn't that cut in favor of the reasonableness of trial counsel's decision ultimately not to subpoena them? That he was aware of them. We have steps and a log of efforts that he made to try to get to speak to them, scheduled appointments, which they missed. And this is this is a little important record. Is he the brother or the god brother of the appellant?
One was the teenage brother and one was the godbrother. So Davis, who had testified in the grand jury, was his brother. He was a teenager. But
So
yeah.
I guess that's what struck me as a little odd here. The family, the mother, they all know these two witnesses. The appellant knows the two witnesses. The appellant had communication with the two witnesses, all while the attorney is trying to reach them, has scheduled appointments with them, has gone to the neighborhood where they usually hang out. So to me, this would be a little different kind of case if these were transient potential witnesses, unknown to the appellant or to many in the community. And so it doesn't seem, I guess what we, under COSIO, the standard we're looking at is whether the attorney's efforts to investigate were reasonable. And it doesn't seem unreasonable that after the steps that were detailed over a period of time to people known to the appellant and his family, who knew the serious charges he was facing, who don't show up to appointments that were scheduled, doesn't seem unreasonable that the counsel would decide, nah, I don't know that I want to risk subpoenaing them and given their track record so far?
So I guess the three things I would say to that are, number one, if that was the case, then I think he wouldn't have listed them as possible witnesses at the beginning of trial. But number two, trial counsel was asked, I mean, granted, these kids were certainly could have been more conscientious about keeping appointments. There's no question about that. But trial counsel said he didn't think they were actually like intentionally avoiding him. He just thinks they had a lot of other things going on in their lives. You know, I mean, they were maybe unusually flaky, but he doesn't think they were like dodging it. And you know, and so there is no reason to think they actually, once they had to be somewhere and couldn't leave, which is exactly what happens when you subpoena someone, there's no reason to think they wouldn't have talked to him. And I think, you know, the government subpoenaed Justin Davis, and not only is there no evidence suggesting that trial counsel made any effort to have his investigator talk to Mr. Davis during actually quite a bit of downtime before the defense case starts, but the way trial counsel testified, it seems to suggest he was like, oh, I imagine he would have been outside the courtroom. It wouldn't have surprised me if Davis had been sitting outside the courtroom during the trial, as if he was kind of, you know, viewed it as kind of almost viewing himself as a bystander in that whole process. And so I can understand if at the end of the day, he made a strategic decision. Even when they were subpoenaed, I couldn't talk to them, or I talked to them and I got a bad vibe or something like that. But Davis was right there, and Evans could have been right there, but for a subpoena. But the other thing I want to say is I want to talk about Davis's grand jury testimony, because, I mean, I've never in my trial.
Before you go there,
Yes.
let me ask you to also address in it the two statements, well, perhaps even more than that on the record, that I noticed where both of these witnesses were like, I would do anything for him, or I would do whatever I could to support
Right.
and have the potential bias there, which I know relates to
Right.
that as well.
Well, first of all, clearly they wouldn't show up for their appointments. So I think obviously they're not totally in the tank for him. But so that's the first thing I would say. But the second thing I would say is, well, two and a half things, I guess. The second thing I would say is Dante Evans was actually asked about this at the hearing. And I mean, I wasn't in the hearing, but boy, he seemed emphatic. I mean, he was like, I am not adding a day to my prison sentence by lying. I don't care who this guy is. And if they had asked me to talk and I knew he was a murderer, I would have told the CEO, just like, take me back to my cell. So he was pretty emphatic. And if you look at Davis's grand jury testimony, I mean, I know the government describes it as confusing. There were a lot of follow-up questions from the grand jury, although if you look at them, he actually answers all of them quite specifically. And at the end of all of those, when the questions start with "I'm confused," they usually end with the grand juror being like, "Oh, okay." And he didn't have much of a filter, right? And that, on the one hand, made him not a professional witness, but on the other hand, did give him a certain credibility. Ultimately, that's a question that would be up to the jury to decide. All we need to decide is there a reasonable probability? And remember that we are comparing this to significant credibility problems on the government side, including the government's, the government's main sort of third-party witness, testifying about a supposed request for a gun that she had omitted from multiple statements to the police, and in any event, not putting Mr. Sims at the scene of the, having this. The government's theory was Mr. Sims was crossing the street when the car at the other end of the street, and according to the government's main witness, he was hanging out in front of the building further down. So all of which is to say the government's case had many problems, as reflected by the hung jury on both shootings in the first trial and the outright acquittal of one of the two shootings in the second trial.
See, that seems to cut at least both ways, if not against you, in my view. So you had talked about how your client was upset after the first trial, and that made the need to call these witnesses all the more salient. It seems to me that government didn't get a conviction after the first trial. Defense counsel had now seen preview of the government's case and all the weaknesses that you just identified, and could strategically think, I can go into the second trial. These two witnesses didn't testify at the first trial, am I right? Obviously.
That's correct, yes.
Right. I got a hung jury without these witnesses testifying. I've now seen all the weaknesses in the government's case. I don't see any benefit to calling these two guys when I haven't even met with them. I can win this case the second time around.
Trial counsel never testified that that he said, you know what, there's no point to these guys. I just have to do everything I did in the first trial just a little better. I mean, maybe that's what he was thinking, but that's not what he testified to. And again, if that was what he was thinking, he wouldn't have announced them as potential defense witnesses at the beginning of the case. And at the end of the day, again, I think if he had subpoenaed them, or if he had attempted to interview Davis, who was already under subpoena, and said, yeah, I don't want to call them, I think that, would be hard. That would be hard to challenge, but there is no explanation for not subpoenaing Evans, which did not obligate him to do anything in terms of calling him.
Can I ask you if,
yes.
You've said a little bit about how the existence of the first trial changes the calculus here, but let's take that out for a second and
Yes.
say we've only got a normal case with just one trial.
Yes.
Defense counsel tries for months and months to reach these folks and can't do that. And then he or she stops trying about 3 months before the sole trial that we're talking about. Is that deficient performance or failure to investigate?
I think it would depend on how important the witness is and what else we know about him. But I would say if there is a 48-page sworn grand jury statement that you already have, in which the witness puts, says the shots rang out 30 seconds after Sims entered a building way down the street, I think it would be deficient to not at least subpoena the person. I still see if you subpoena the person and the person won't talk to you even in the courthouse, or you get a bad feeling. But I think that's the thing with Davis too. This was not a blank slate at all. 7 or 8 months before the second trial, trial counsel knew that Justin Davis says Sims walked into the apartment building across the street, and about 30 seconds later, the gunshots started, which makes it impossible for Sims to have been the shooter.
Well, I guess you wove in a little bit about prejudice. If we did agree that there was deficient performance by counsel here, is there prejudice given the government's case? If you could speak to that quickly, and then you haven't addressed the IPA claim.
Yes, and I see. So, by the way, I see my time has expired. I'm assuming. All right. So on prejudice. So I think the first thing is you have to look at the strength of the government's case, and the government's case had multiple problems, including the testimony I just mentioned of the, as well as, eyewitness identifications that were extremely suggestive.
But they did have some strengths, quite a few strengths. The eyewitness identification by someone who knew the appellant, and the appellant's change in his own testimony, which could raise his own grand jury. Where was his deposition? He changed his story,
yes. Yeah.
And that raises credibility issues, or could raise credibility.
It could, although on that point, this court in its previous prejudice, analysis of prejudice in other Sixth Amendment decisions has noted that one thing you have to consider is if you had this witness, would the defendant have even needed to testify? And so here, and by the way, I want to make it clear, our argument here does not depend on it does not depend on your believing that trial counsel told Sims to change his story. We do not need that fact to make this argument. But the argument, there is testimony even from trial counsel that one of the things that seemed to be motivated Mr. Sims to testify was that he felt like there weren't any additional witnesses, and that one of the other concerns that trial counsel had was that if Sims testified that he was in this apartment building, there was no corroborating witnesses. So if you had even one, let alone two witnesses saying actually he was in this building at the time of the shooting, number one, Sims might well have decided not to testify, and number two, even if he had decided to testify, he probably wouldn't have changed his story, because these two witnesses were actually consistent with what Sims had told the police, which was, yes, I was in this apartment building when the shooting took place. So a lot of things would have actually,
for changing his story has to lay with him, right? No matter what his attorney did or didn't.
We're not saying that his attorney was ineffective because he changed his story. I'm simply saying that when you're looking at the prejudice analysis, Mr. Sims even testifying is not necessarily baked in, and this court's cases have reflected this. one consequence of calling one or more additional witnesses is that that may well have affected the decision to testify.
Yes, and I get that, and I very much agree with it. But if he testified completely truthfully and didn't have the bombshell video impeachment, then that would not have mattered as much, would it?
That was not a good moment for the defense. I'm with you on that. I mean,
It was
and
not, but that's solely his responsibility unless we somehow, and I get, you're saying we don't need to find that his
Right.
counsel told him to lie under oath. That we can't use that as part of that consideration, can we? Like, that's not really fair because his decision to lie under oath was his decision to.
the way I think it is properly used is that not so much, I think it's merely that when you're evaluating prejudice to reasonable probability, you're not saying, well, you should not assume that in the alternative world with these two witnesses that Sims would have testified or testified in the same way. So that isn't dragging the case, I guess, is what I'm saying in the event you have these two witnesses in the prejudice analysis.
And the IPA claim?
Yes, so I'll address it briefly. I think the first point about the IPA claim is that I think it reinforces the deficient performance with respect to the 23-110 because most of the things that the trial court said about the IPA claim and that the government said about the IPA claim with respect to reasonable diligence are exactly our point. That he could have subpoenaed Evans. He knew where to find him. He could have given him a piece of paper and brought him to court.
But doesn't the IPA, when it talks about reasonable diligence, go a little more broadly? It's not suggesting that the appellant should have subpoenaed anybody, but it does seem to encompass at least the inquiry of what the appellant did do to aid in his putting his case forward. And that seems to be where we would look at the fact that the appellant knew these people. One is his brother, his mother. They all knew where they were, how to get them to where they needed to be interviewed by counsel. Isn't that where the reasonable diligence piece cuts against appellant? We're not suggesting that he had the burden to subpoena. That would have been the purview of his attorney, but what he did or didn't do is important when we're looking at the IPA claim, perhaps in a different way than clearly when we're looking at the ineffective assistance of counsel claim, we're focused more on counsel.
So I want to make, I guess, both a legal point and a factual point, if you'll permit me. The legal point is the IPA uses the word quote movement, but it is not saying individual movement. There's no place in the IPA where in one part of that subsection it says counsel and in the other part it says client. So movement, I think, is very much a sort of referring to the defense unit in the same way that a judge would say, when I write a motion and file it, the judge will say movement argues that, that what they're saying is, yeah, Mr. Lipper wrote a bunch of words, but we're attributing them to the client. And that's why we're using the word movement. And I think that's the way the statute is being used here. And if I could just add one detail on that point, there was a second IPA claim. We're not presenting it on this appeal involving a particular police memo about one of the witnesses. And in that case, Sims testified, look, I didn't know about this until after trial, but trial counsel said, well, yeah, but your attorney knew about it before trial. And that provision, that subsection of the statute also uses the word movement. So it can't mean lawyer in one place and client in another place. And also because I think, especially when you have a defendant in jail, I can tell you, and I think most lawyers would tell you, never want your client to talk about the case with anyone on the phone because the government, the calls are recorded, the calls get sent directly to the government. On the facts, though, I think we can look here as I think it's quite speculative to say that if only Sims had called up his brother and said, show up to your appointment, that would have fixed things, because we have kind of a control group here, which is that trial counsel did testify that he talked to Mr. Sims / Mr. Davis's, or talked to Mr. Sims's mother, who is, Davis's mother and, Mr. Evans's kind of godmother. He told her, can you really get these guys to show up or get these? And by all accounts from trial counsel, she was trying, they were talking, and she wasn't able to do it. And she's out in the community and sees them, if not every day, quite frequently. And so if his mom wasn't able to do it, I think it's quite speculative to say that a single phone call from Sims behind bars, when at best he needs to be discussing this in very general terms to avoid, would have changed anything. And I think that's one reason why the IPA doesn't impose a sort of granular client specific requirements. I mean, even the fact in most IPA cases, we don't even have the reason.
Right, but the IPA is not merely another ineffective assistance of counsel claim. I mean, it is looking differently.
Yes,
at the situation.
Absolutely, that is absolutely right. But I think in my only point is in this case, when we're looking at the same sort of efforts to procure witness testimony in some form, and under these circumstances, it can't have been simultaneously reasonable when we're on section 1 and then unreasonable when we're on section 2.
But the only way for that to not also apply to your argument is if you're solely hanging your hat on the failure to subpoena and prep in the courtroom hallway versus the investigatory efforts pre-trial to find these folks, right? Because you're saying, even the mom couldn't get them to come. So that cuts in favor of the government with respect to the reasonableness of the efforts before trial, right?
But again, that's why we have subpoenas.
Right. So I guess that's what I'm saying. Like your argument really boils down on deficiency to the failure to subpoena and prep in the courtroom hallway.
I actually do want to quibble on the hallway point because first of all, there are
fair enough.
There are 2 quote, witness rooms designed specifically because many witnesses, are being talked to, including on both sides of the case, are showing up for the first time on the day of trial. So there are rooms in each courtroom designed specifically for that purpose. And trial counsel had an investigator, and it was going to be at least a day or 2 before the defense, or more, before even the defense case would even start. So there would have been plenty of time. And again, the witness has nowhere to go. He's not allowed to leave. So there would have been plenty of time to speak to the witness, plenty of space to speak to the witness privately. And again, and so I don't think it's just this kind of grab, fly by night operation, 5 minutes before the trial started.
All right, Mr. Lipper, unless my colleagues have any further questions, we'll let you reserve a couple minutes for rebuttal.
Thank you.
May it please the court, Kevin Burgess, the United States. I will begin with the ineffectiveness claim. And I think as the court's questions indicated, there are really sort of 2 strands to this. And that's, did now Judge Nolan make reasonable efforts to find these witnesses? And then the other question then becomes, would it also be reasonable for Judge Nolan to not put these witnesses on the stand basically cold? And I guess I will begin. I'm happy to answer any of the court's questions with regards to which of those situations the court wants to focus on. But I guess I will just begin with the reasonable efforts to locate these individuals.
Can I ask you, we're pretty familiar with the factual log and much of the testimony by trial counsel at the 23-110 hearing, but the government cites a case from Tennessee, I believe, as support for why these efforts here were reasonable. But there's some factual distinctions in the Tennessee case that I think I'd like to hear you speak to. And one is the fact in the Tennessee case you referred to, there was no contact information for the witnesses. Here, we knew who the witnesses were. We had contact information. We had close family members who knew who they were. So can you talk a little bit more about why you feel that case was helpful to the government's view that this was reasonable?
I think the main reason why that case is helpful is that it just, and the trial court cited it as well, is just that it stands for the basic proposition that in a very serious criminal case, it would be very risky to essentially put a witness on the stand cold. And that's the passage that the government, I think, is really focused on in that case.
How do we distinguish between subpoenaing them and not putting them on, and not subpoenaing them and not putting them on here?
Right. Well, I guess, do you mean?
They weren't subpoenaed, and as defense counsel argues, if they had been subpoenaed and then there had been a decision not to have them testify, then that might have taken us out of the realm of an inquiry on ineffective assistance. Here, they could have been subpoenaed and then ultimately not put on the stand, and that didn't happen.
Right. Well, I guess I'm a little unsure then what would be the purpose of subpoenaing them if you weren't to put them on the stand. I think I interpret appellant's argument at least to be that they should have been put on the stand.
Well, no, I think it goes more to the investigation aspect of this, which is you couldn't prep them before trial, but you could prep them at the courthouse, literally. So you could have subpoenaed them to secure their presence. And then we got into a little back and forth on how long and how intensive that preparation would have been able to have been conducted, and we don't know the answer to that, but.
Right.
And I guess to end that question, that prep could have then resulted in a determination whether to call them or not, and maybe you wouldn't call them, but at least the prep took place.
Right. So yes, on that specific point, I guess I would disagree with appellant as to how realistic of a scenario that is. I mean, if you're Judge Nolan and you're preparing for a pretty serious criminal case, it's a felony 1 trial, and he and his investigator have obviously made efforts in this case. They have a certain defense that they want to put forward. They have a way that they've prepped this case to then basically in the middle of trial or the eve of trial, whichever it would be, to take a witness into a witness room for 20 minutes. I'll just throw out that number. We don't know how long it would be, but sort of that ad hoc investigation in the middle of trial, I would say would be pretty risky. I mean, could some lawyers do that? Sure. Some lawyers who have a higher tolerance for risk or doing things on the fly might decide they want to do that. But of course, the question here is whether not doing that is so deficient under the 6th Amendment that Judge Nolan is not functioning as counsel. And so I think, a lot of the briefing and a lot of the arguments here today, I think sort of boil down to, could Judge Nolan have done things? He could, any counsel could do any number of things, right? But I think the question is whether his actions were reasonable. I think it's certainly not unreasonable to not want to try to drag someone into a witness room for, again, let's say 20 minutes right before trial or in the middle of trial and change your entire trial strategy based on an interview that could have taken place, right? So I think I would say that appellant exaggerates sort of the effectiveness of that possibility.
If we were to agree that that was deficient performance by counsel, can you tell us why there was no prejudice?
Sure. I think a lot of this just goes to the strength of the government's case. And there already has been a direct appeal in this case, I would note. And Mr. Sims brought up different issues in that case, but at the end of the opinion, this court held that even if Mr. Sims was correct about the various evidentiary arguments he was making, it would have been harmless error. And the court has an entire paragraph. This is the MOJ from, it looks like it is 2009, that basically talks about how both victims had ample time to observe Mr. Sims during this argument in front of the car. One of them recognized him from the neighborhood. And it's not just the hammer testimony, which we've sort of referenced in passing today, but it's also the fact that there was a middle-aged woman who was standing there who points police to Mr. Sims as he's going down the street. Then Mr. Sims takes off and runs. I mean, I think that's a pretty strong case. When you have two ID witnesses, another sort of middle-aged woman, arguable ID witness, plus the hammer testimony.
But counsel, these are all witnesses. It's all testimony. If we've got two ID witnesses, why would two alibi witnesses not have pushed back on that and weakened the case significantly?
I don't think that, well, I think the first thing I would say is that Mr. Davis and Mr. Evans, I think their testimony does not actually establish an alibi for Sims. And I think this is important because a lot of appellant's briefing has focused on the fact that if Mr. Evans and Mr. Sims are to be believed, then Mr. Sims must be innocent. But I don't think that's actually true when you look at their testimony carefully. They both say that they see Mr. Sims enter this building, okay? And the shooting happens about, I mean, I think at the evidentiary hearing, you know, the shooting happened, both witnesses indicated the shooting happened a short time after that. Then they run inside of a house when they hear gunshots. They don't see what happens for 2 or 3 minutes. Then when they come out of that house, one of them, Mr. Evans, says he sees Sims exit the building. The other one, Mr. Davis, says he saw Mr. Sims come from the direction of the building. But they have to admit they weren't there for the shooting. They didn't see the interaction with the fight between the two victims and Mr. Sims near the car. They don't see any of that. I mean, I think it's really a stretch to say that, you know, the argument never happened, that the dispute never happened in front of the car, that you know, these witnesses just don't see the shooting. I think the only other thing that I would say is that, you know, these witnesses are obviously biased for Mr. Sims. I mean, one is his brother. The other said is he feels like Mr. Sims is like his brother. They all grew up together. They say at the evidentiary hearing they would do anything for each other.
Counsel, I realize you're responding to a question, so I don't hold this against you, but in your briefing, I think you acknowledged that if we were to reverse or vacate on deficiency, we would have to remand for a finding on prejudice or further ruling on prejudice by the trial court. Are you now suggesting, and again, I realize you were answering a question, but are you now suggesting that we could reverse on deficiency and affirm on prejudice ourselves?
I think this court could do that, but I think the better practice would be to remand for Judge Dixon to make a finding on prejudice in the first instance. And Judge Dixon, you know, has a footnote in his order where he explicitly recognizes he's not making a finding on prejudice, but that he doesn't have to, citing this court's case law. So I do think it would be better to give Judge Dixon an opportunity to make that finding, especially because Judge Dixon was the trial judge in this case. So he is familiar with the evidence and all of these witnesses and would be in a good position to make that finding.
Can I ask you, you spoke about the subpoena piece of this, but looking more at the efforts to find them before that ever came into play. A two-part question, if you don't mind. One is, which way does the evidence cut on efforts, if any, to locate them between the two trials? And two, if we assume zero efforts to locate them between the two trials, is that a reasonable conduct by the defense attorney?
So I'd say on which way it cuts, it would cut against the defendant because it is the defendant's burden to show deficiency. I think if there is, in fact, zero evidence, I think Judge Nolan is still not deficient because he has made so much effort. He and his investigator have made so much effort throughout all of these proceedings. And it is true that Judge Nolan, when he testifies, he doesn't delineate between when I did these things, did I do these things before the first trial or before the second trial, right? He doesn't separate it out like that. But even assuming that there was zero effort in between the trials. I mean, if you're Judge Nolan, he set up 4 to 5 meetings with these guys combined. They haven't shown up. Judge Dixon did credit Judge Nolan's testimony with regards to his efforts to get these witnesses. They've gone out to the Saratoga Avenue area over a dozen times. They've tried to get in touch with them through the family, and that has not worked. But I think also importantly, Judge Nolan, and maybe this can also transition into the IPA discussion, which I'm happy to talk about. Judge Nolan has asked Mr. Sims himself to help, to get Davis and Evans to get in touch with him. And Sims admits at the evidentiary hearing that he didn't do anything to do that. And so I think if you're Judge Nolan looking at the situation, he's made all this effort, but how important can these witnesses really be? Because no one is helping him. His own client is not helping him. The family is not helping him. These 2 guys are not helping him. Obviously, they're sort of blowing him off. And so I think a reasonable attorney would say, these guys are not actually that important for this case.
Well, sorry. I mean, we know they're important, right? Because putting aside whether they're telling the truth or not, we know what their testimony is going to be. And that is, well, I know you questioned whether that was a direct alibi, but it seems pretty close to a direct alibi. So seems pretty important.
Well, with regards to Davis, he at least has, yeah, it's true. He has some idea of what the testimony would be because he has a grand jury transcript. And obviously we pointed out what we think are certain inconsistencies in that transcript and confusion. And I won't go into detail about that, but he has some preview of what Davis might say. With regards to Evans, I don't think he really does have a preview of what he's going to say. And in fact, it's Sims with regards to, I believe it is Evans. He admits that he did not tell Judge Nolan exactly what Evans's testimony would be. And so Sims is sort of telling Judge Nolan, look, I think these guys would be helpful. I want you to get in touch with them. Great. So he does make efforts to do that, but he doesn't know concretely what they're going to say. And given the fact that he doesn't know that, and all of the sort of, I guess, brushback he's received in terms of nobody helping him find these guys, at a certain point, I think he has to say, I mean, I get why I made these efforts to find these guys, but they can't be so crucial for this trial, given that nobody else is making an effort to help me find them.
You said you wanted to touch briefly on the Innocence Protection Act claim.
Yeah, so I'll just touch on that very briefly. I mean, I think certainly the testimony of both of these individuals is known to the defendant and Judge Nolan before the fact that they could be witnesses is known to them before the trial. So it's certainly not new evidence in that sense. And so then you have to look at, well, could Evans, and the IPA claim is only with regards to Evans, not to Davis. Could his testimony have been compelled, and did the move-ins show reasonable diligence? I mean, as we argue in his brief, Evans was very difficult to find. He could have been compelled. He could have been subpoenaed. I think that's been almost everyone's agreement here today. And so I just want to focus a little bit on reasonable diligence by the move-ins. I wouldn't say, and I think a lot of appellants' argument here is trying to point to other potential, a parade of horribles of other cases or other potential dangers without actually looking at this case. So I would not say that under the IPA, a defendant always bears some sort of affirmative obligation to do something. But I would say here, where Mr. Sims is telling Judge Nolan to try to find Evans, and Judge Nolan is saying to him, I can't find him. Can you help me find him? And Sims does nothing to assist Judge Nolan. I would say that is not reasonable diligence by the movement. And I think that my opponent basically indicated in response to this court's questions that the movement can be a unit. Well, even if that's true, like the defendant is part of that unit. The defense counsel can be part of that unit, of course, but so is the defendant. And I think Mr. Sims does bear some responsibility for not doing anything at all to help his counsel here. And I think really we don't need to go into obstruction of justice or substance or anything like that. I think all it needs to be is when he's talking to Evans before trial, and he admits he talks to Evans several times, he just needs to say to him, hey, can you talk to my lawyer? That's it. But he doesn't even do that. So based on all of that, we would ask, unless there are any further questions, that the judgment of the Superior Court be affirmed.
Right, thank you. Mr. Lipper, we said we'd give you a couple minutes for rebuttal.
Thank you. I appreciate that. I'm going to make 3 points if I can. The first thing is I want to start on prejudice. The government was, talking about the strength of the government's case, but I think this is telling. One of the examples they gave was, well, there was an eyewitness, and I think it was Mr. Anderson, who knew Mr. Sims from the neighborhood. Mr. Sims was acquitted of shooting Mr. Anderson. So however strong that testimony might have been in some other case, in this case, the jury clearly was not persuaded by even the identification of someone who says he knew Mr. Sims from the neighborhood. That's the first point. The second related point is on the government's suggestion that it's not exculpatory because Mr. Davis wasn't present at the shooting, or he was. Of course he wasn't. It's an alibi witness. If he were present at the shooting, then that would not be an alibi. It would be at the shooting. And I just want to be very clear, because Mr. Davis's testimony to the grand jury, and he says this twice, 30 seconds after Mr. Sims entered the building across the street, he heard the first 2 shots, and then the remaining shots a few seconds after that. Like, unless Mr. Sims was the flash, there is just no way that he could possibly have been at the scene of the shooting down the street shooting someone 30 seconds after he entered the front door of his apartment building. So that is about as ironclad an alibi as you can imagine. And then this takes me to my third point, the suggestion that he would have been calling Mr. Davis cold or basically cold or had no idea. Again, he had a 48-page grand jury statement. Mr. Davis had very detailed recollection. At one point, the grand jury was, wait, you were going to play a CD from the car? And Davis is like, yeah, it's a song called Go DJ, and it's the song that the baby likes. And the juror is like, oh, okay, that was nice. He's like, if an investigator who can come back with a 48-page sworn statement from a potential witness is an investigator who's getting like a significant salary increase, because that is an unusually detailed statement, at the very least, it warrants a subpoena and some additional discussion before trial. Unless the court has any questions. Thank you.
All right, thank you. We thank both parties for your briefs and arguments today, and we'll take the matter under advisement. Thank you. Our next case this morning is EMERO TORNERO versus United States. Oh, we have Mr. Burney is arguing both cases as well. I was wondering why no one was moving here.
Good morning, Your Honors. My name is Tom Burgess. I represent Mr. Tornero.
All right, good morning.
Good morning. I would like to reserve 3 minutes for rebuttal.
All right, thank you. And counsel, if you could just get a little closer to the microphone. Sometimes the podium raises also, but it may be up as high as it can go.
Yeah, I believe there's a switch on one of your sides at the back side. Back. Like where the. Sorry, not there at that level, like literally on the
Oh,
columns.
I'm sorry.
Oh, wrong. It may be up as high as it goes. Just need you to speak a little louder.
Okay, yes,
Thank you.
yes, Your Honor. May I please the court? Mr. Tornero in his 23,
You started to say you wanted to reserve.
oh, I'm sorry, if I could get 3 minutes, if I could get 3 minutes here.
All right, thank you.
May it please the court, Mr. Tornero in his 23-110 motion alluded or argued, one of his arguments was that his sentence was illegal. His brief to this court argued that his sentence was illegal because at the time the alleged conduct occurred, the statute did not authorize a fine. That
Can you tell us why what your argument as to why the fine that was assessed for his ADW charge, why you call it a fine versus victims of violent crime assessment?
I call it a fine because it has all the trappings and the markings of a fine. It's only opposed if the defendant is convicted. It has gradations depending on the severeness.
But counsel, your brief doesn't cite either of the two cases that bear on this question, Lopez Ramirez and a case called Gote. And I mean, query whether they're directly, explicitly controlling, but they seem to grapple with the very questions that you're raising now, but you haven't grappled with them in your brief.
Well, if I have been trying to grapple with them subsequently, and I don't think that Lopez Ramirez is controlling in this case because it was, it expressly said, I think, or I'm not sure if it was expressed, but it alluded or suggested that it was not making a decision about what assessments mean for the case of the VVCCA. It was determining what the meaning of a fine is in the context of a statute which concerned jury trials. And the court in Lopez Ramirez, as I understand it, basically said, we can't, for the purposes of this statute being the jury statute, conclude that the VVCCA is a fine, because that would defeat the purpose of the Streamlining Act and the general purpose to control how many trials would be jury demandable. Regarding Gote, as I understand that case to really hinge the rationality under that case was that the defendant had not actually pled guilty when the court imposed this fine. And so on that basis, it could not be levied as a fine, though it could have been levied as the VVCCA.
I think both of those cases, I mean, in Lopez Ramirez, I agree with you, it was dealing with a different context, but it parsed the VVCCA statute in order to explain why, as a statutory interpretation matter, those assessments are not fines. And then in Gote, I think that the natural conclusion is the court said, yes, you could not have imposed this amount as a fine, but you could have imposed it as an assessment under the Victims Act. So don't both cases together kind of lead inexorably to the conclusion that these assessments are not fines?
Well, so I guess Your Honor puts Lopez Ramirez on the table and then combines it with Gote. But I don't put Lopez Ramirez on the table because as I read the case, it was careful not to reach a decision on what assessment means in the context of a VVCCA. And I would point out that the dissent in Lopez Ramirez forcefully argued that it's very difficult to not view the VVCA assessment as a fine or at least a penalty. And So I do think it was a fine, and the AD assault with a dangerous weapon statute did not authorize a fine at the time of my client's alleged conduct.
Well, but if we look at the language of the Victims of Violent Crime Act statute itself, it starts out in A1, 4-516A1. It says, in addition to and separate from punishment imposed, an assessment, and then it gives the amounts of the assessment. So and that language seems pretty clear, and this statute was in effect prior to the amendment to the ADW statute. So that, such that in addition to sentencing Mr. Tornero for the ADW, the trial judge was required under the language of the VVC after sentencing to impose this assessment.
Yes, Your Honor. So, elsewhere in the statute, the statute says that it's to be collected as a fine. And so the language that Your Honor references.
But that cuts both ways. If it's to be collected as a fine, then that seems to signify that it's not a fine, but that you would go about collecting it in a similar manner.
Well, I think that assumes that there cannot be two different fines from different sources. So this is a different source of a fine. And in the language that Your Honor read, it does use the word assessment. And assessment is used throughout the code in connection with penalty.
Counselor, you can assess a lot of things. I've got kind of two questions for you. The second one will be kind of a hypothetical, perhaps not even a hypothetical, a little more direct. But the first is, along those lines, what do we make of the history here that when it was purely a fine under the previous iteration of the statute, the city council found that judges weren't really assessing this fine, and it was not funding the fund that it was supposed to fund for the VVCC, maybe one more CA. And then they changed it. They took the discretion away and said, you're going to assess these amounts. Did that not take it out of the fine category and put it into something new for you?
Is this a reference to the 1981 iteration or the amendment to the 1981 iteration in the 90s? I'm sorry, Your Honor.
It could be either. I'm saying under a previous regime, judges had discretion with this, and it was explicitly a fine, and they were supposed to be levying that. And then the discretion was taken away. They weren't levying it. And I guess I'll go straight into the second question for you. As I look at this looks like a tax to me. This looks like and I'll say an analog to a tax. We wanted to support the Victims Fund as city council, and so city council decided, I'm going to take away all the discretion, and as long as someone fits in this category, just like someone would on different levels of income and percentages, with this levels of severity here, I'm going to assess this assessment, whether you want to call it a tax or whatever else, and it's going to fund this. There's no punitive nature to it.
Well, I would posit, Your Honor, so the different gradations, it doesn't track to the victim, the number of victims, say, or
it does track to the severity of the crime. Your point's well taken, and perhaps that's more of a red herring in the example I was giving. That's just another way that they're similar. But really, for me, it looks like city council said, I want a revenue generating measure, not a punishing measure. And I want it to fund this specific thing, which, though it's linked to this punitive system, I think it would be fair to potentially take the view, and I want to hear your counter argument to it, that really this is a tax. It's here to generate revenue. These are the folks we feel should be responsible, and there's no discretion for the judge like there traditionally would be in fines and other penalties, et cetera.
right. So I just, if I were to think of a tax, it would be proportionate to sort of the amount of resources that's being expended by the court for each victim or charge. But here, my client faced a 17 count indictment. If he was convicted of just one of those, he could be fined up to $5,000. Another person could be faced with just one count or one count indictment, be convicted of the one count indictment and be fined the exact same amount of money, even though the resources and the required court resources, the required judicial resources are much more in a 17 count indictment than it would be in a single count indictment. I'm not sure regarding Your Honor's first question. I thought that in the revision of the statute, the issue was that the funds that were being levied weren't actually getting to the victims. And so the VVCCA, when it was amended in the 90s, made the court in charge of actually getting the money to the victims, was my understanding, but I'll stand corrected. I'm not positive about that, but I think that's sort of what was happening back then. But to go back to that, I think the statute's clear and the way the statute functions.
Well,
yes, Your Honor.
Glad you said that. If you think the statute is clear, because I wanted to ask, your argument seems to be more of a policy argument and not a statutory interpretation issue. And if that's the case, then what is the relief that you're seeking from us? If the statute is clear, and if we think it's clear that it is not intended as a fine, that's part and parcel to a penalty that is imposed in sentencing for commission of a particular offense, but it is a separate assessment for perpetrators of criminal matters to be taxed, to pay for victim services, their therapy, extraordinary medical attention, other things like that. If we think the statute is clear and that's what it says, then what would be the remedy that you would seek here that wouldn't involve an amendment to the statute, which would not be within our purview?
Well, so if the court thinks the statute is clear that it is not a fine and that it is a mere assessment, then I would not think that my client's sentence was illegal because he has not been fined. He's just merely received an assessment. But my argument is that he was fined. And therefore that creates a number of problems for him because he looks at a criminal statute from 1901 to, I'm sorry.
No, go ahead.
He looks at a criminal statute which says the only crime that this person is going to face is jail. And then in another statute outside of the criminal code or the criminal section, it tells him that there's going to be an additional penalty and it's going to be a fine. And I would just present to the court, suppose that a statute that was very specific to a particular crime only authorized a fine. And then in a separate statute outside of the criminal provision authorized incarceration. I think we would have a big problem because I don't think there would be fair notice to the.
So counsel, is your argument, I know you're not making necessarily a constitutional or policy argument, but well, maybe you are, but purely from a statutory interpretation question. If the VVCA, if the thing at issue looks like a fine, sounds like a fine, smells like a fine, but the VVCA said even more clearly than it does now, this is not a fine. That's the first thing it says. Are you saying that we could override that statutory language to say this is a fine despite the city council's, DC council's express statement that it's not a fine?
No, Your Honor. I think you start with the plain language of the text. And if the plain language of the text is clear that this is not a fine, then that's controlling. I don't think the plain text is, I think the plain text is clear. It's read in context of all the ways that it functions throughout the statute, from the way that it functions and from the language itself. And if I could go back, Black's Dictionary, as the dissent in Lopez Ramirez points out, groups all of these terms like penalty, assessment, fine. They're not in and of themselves indicative that this is not a penalty or not a fine. And the other language, which I quote, which Your Honor points out, cuts both ways, but also cuts my way, if it also cuts the government's way. Those are all in addition to the way it functions with the gradations, all of that shows how this, how the council saw this, which was as a fine.
All right. Mr. Burgess, you want to reserve? Well, we've used your time for questions, but we'll give you time for rebuttal.
Okay, yes.
Mr. Bernie?
May it please the court, Kevin Burney for the United States. I'm just going to have a very straightforward oral argument, I think, because I don't think, frankly, that this court needs to reach the question of what Lopez Ramirez says and Gote says in all of these cases. I know we have cited those cases, but really it's just sort of an aside to indicate that this court has so far distinguished between assessments and fines. The appellant has not made any arguments. He's not made any constitutional arguments. He has not sought to attack the VVCCA statute. His brief doesn't acknowledge the VVCCA statute. And so I would say that his brief, the only argument that his brief actually makes is that Mr. TORNERO received a fine, but he didn't receive a fine. If you look at the judgment in this case, the amended judgment after the direct appeal, next to the dollar amounts, the Superior Court specifically puts VVCA. And the statutes in place at the time, and this is DC Code Section 4-516, says that an assessment of between $100 and $5,000 for each felony offense shall be imposed. It shall be imposed. The Superior Court has no choice but to impose it.
Right, but I guess not to make counsel's argument for him, but wouldn't it be that, okay, you start with the ADW statute and it says no fine. Okay, now the judgment says this is under the VVCCA fine. Well, sorry, double use of fine there. Okay. Then you go to the VVCCA, it calls it an assessment, but the council has otherwise used, or at least in reasonable interpretation or under dictionary definitions, assessments and fines are used interchangeably. And so the VVCCA itself doesn't necessarily tell us that this is not a fine. And you can have fines from multiple sources. You can have a fine under Title 21 and you can have a fine under any of the other titles in the DC code. And sorry to make this such a long question, but in that regard, I did find cases from our court, and I'm not saying they're dispositive on this, but they say, they often just summarize what the sentence was and they say, and a fine under the VVCCA. So clearly it's not completely unreasonable that assessments can also be fines.
I mean, certainly that argument has been presented to this court, certainly. And you could argue that a variety of ways, but Mr. TORNERO has not made that argument. He has not made that argument in his brief. His argument in his brief, I think, is 2 pages. It doesn't discuss VVCA assessments at all. And so, at this point, I think the only thing that is actually before the courts is, did the Superior Court properly apply a VVCCA assessment? pursuant to the statutes. And that's exactly what the trial court did. It has to do that. It imposed the exact minimum, $100 that it could have for each of the relevant counts. And so I think there.
Counsel, let's say that I'm reading the brief statement that this was a fine as implying this argument. And, the argument essentially boils down to, something akin to that which we call a rose by any other name would be as sweet. That which we call a fine by any other name would still taste as sour, right? And I felt like in Lopez Ramirez that the dissent was pretty compelling. What argument do you have that this isn't just a fine by another name? I know this is just a different reiteration of Judge Schenker's question, but.
I mean, that is a huge argument which has not been briefed. And I can cite to Lopez Ramirez. You can go back to the statutes. I mean, I can note things that Lopez Ramirez notes, such as that in section A, it says in addition to and separate from punishment imposed. That would suggest that it is not part of the punishment and a fine is imposed as a punishment. It says under C, assessments under this chapter shall be collected as fines, which suggests that it is not a fine. And I think there were some questions about that during my opponent's argument. But that is a huge issue that has not been briefed.
What do you make of the point that was briefed, which is that the ADW statute at the time Mr. Tornero was sentenced is different now. It was later modified to specify that fines were possible as part of the sentencing for the offense. The other charges that Mr. Tornero was convicted of in this case had clear provisions in them for fines. So I guess my question is, did the council realize that there was some ambiguity in the ADW statute? Because at the time Mr. Tornero was convicted, it did not include a provision for fines, which they later added in to make it clear that the assessment wasn't a fine.
I mean, I don't think that holds any real significance, I would say. I mean, I think that, the DC code gets revised all the time, as we know. Apparently, for whatever reason, there was no fine specifically attached to the crime of ADW in a prior reiteration. The council decided to explicitly attach a fine provision to ADW. That would bring it in line with most of the other statutes, most of the other offenses in the DC code. Almost all of them have a fine that's attached to them. So,
well, I asked the question because I wonder how this plays into appellant counsel's argument that they had no notice. Mr. Tornero had no notice that he would be assessed, fined, required, whatever the word we want to use for purposes of this argument, that he would have to pay any money. And when the statute was later revised or amended, it put the fine provision in there. So appellant's not challenging the other convictions, which did have a fine provision. And I assume, maybe I'm making an argument that wasn't explicitly made in the appellant's brief, but I'm assuming that they challenged the ADW provision because it did include a fine at the time. There was no notice that the defendant would have to pay anything. Do you have a response to that argument?
well, I think the first thing I would say is I don't think he's made that explicit argument about notice. I don't think.
Well, he made it here in oral argument. I'm not so sure it was made explicitly in the pleadings.
I don't think the ADW statute has any real relevance here. The operative statute that requires the Superior Court to impose this assessment is the VVCCA statute.
How are defendants given notice of a VVC statute that they will be assessed and required to make a payment after they're convicted and sentenced?
I mean, I don't know the answer to that question. Certainly not in every case. I wouldn't know. I mean, there's no record that has been established on this question. Like this argument was not raised in the trial court. None of this was raised in the trial court. Not even this broad argument we've been talking about today was raised in the trial court. It's raised for the first time on appeal. There's no record about it. There's no record as to his notice or his.
I mean, would you argue that the mere existence of section 4516 in the DC code provides the notice? I mean, under the legal fiction that
I mean, yeah,
People
certainly.
are-
I mean, and I,
people are assumed to know the law and the risks that apply if they commit felonies and all the code sections that might apply to them if they commit felonies. I'm not
Right.
making that argument for you, but I don't know if that's a.
I mean, I would probably point to that. I guess the reason why I hesitate to answer on how defendants are given notice in each individual case is I think it would vary quite a bit, you know. Mr. Tornero was convicted at trial, if my memory is correct, and so it's not like there's a guilty plea colloquy where we inform Mr. Tornero, you know, what could happen to him if he pleads guilty. So I think it could vary tremendously from case to case, but I don't think, again, I don't think this is presented to the court right now, but to the extent, yeah, that it would be helpful for me to answer it. I think probably that, yeah, the defendant would just be on notice of the fact that this assessment is possible because it is in the criminal code, like it is required.
Well, here the appellant is challenging the legality of his sentence. So isn't one of the questions we need to decide in this appeal is whether the VVC assessment is in fact a fine?
He has not made that argument. I mean, I really do.
Well,
have
isn't
to
that
stress-
inherent in the argument about, well, he has to some extent made that argument. He says he was fined. And whether we call it a VVC assessment, it ultimately is a fine. These are arguments that were made into Lopez and in Gote. The only basis for the challenge to the legality of his sentence here is the assessment of a fine. So don't we have to determine whether or not a VVC assessment is in fact a fine?
I would say no, because I don't think, even if he's making that argument, it certainly has not been developed. And I think when he says he's been fined, I think he mostly does that in reciting either the standard review or the facts section or something like, I mean, there's no separate argument that has been.
Well,
developed on that.
I'm actually legitimately confused. What do you see his argument? As
I think honestly, I read appellant's brief as not understanding that he was, a payment was imposed on him under the VVCCA. I view him as just not even understanding that there was a VVCCA assessment imposed.
Right,
But
That's a little bit of a stretch.
Yeah, even if that's the case, I mean, that's sort of what my question goes to. In determining whether his understanding was correct or incorrect, don't we have to make a determination about whether a CCA assessment is a fine? If it is, then he would be correct. His client was fined. If it isn't, then what we would be saying is the statute is clear and perhaps he should have known that that was part of the process in a criminal case.
I mean, I guess I take your honor's point, but I don't, it all depends frankly on what we think Mr. Tornero is actually arguing. I mean, I don't think he has developed any argument that tries to distinguish between fines and assessments. And he hasn't developed an argument that says.
Counsel, the point is, why is that on him? Looking at his brief, header A says the applicable sentencing law did not authorize imposing a fine for ADW. I don't see why that's not just a defense to the validity of the sentencing for you to come back. And it's really your argument that what he was hit with was not a fine at all. It was an assessment under this. And so it seems perfectly fair game for him to attack here at oral argument. And it seems perfectly defensible to ask you to support why that is not in fact a fine. And that assessment is something else.
I mean, I would say again that, you know, I don't think that here's why I am resisting sort of that coming to oral argument, the only notice that the government has about the issues that are going to be before this court today are the apparent misunderstanding that he was actually given a VVCCA assessment.
Well, then help us clear up that misunderstanding from the government's perspective. Why isn't the VVC assessment a fine?
I mean, that is a huge question that has been briefed over dozens and dozens of pages in at least Lopez Ramirez, and which has not been briefed in this case. So, I mean, I can on the spot here make several arguments, I guess, that could give this court comfort. I mean, I think the first thing that I would say is pointing at the statute is addition to and separate from punishment imposed. So that language is included because the council wants to signal to this court that a VVCCA assessment is not a fine. A fine is part of the punishment. It's addition to and separate from the punishment imposed. It says in subsection C, assessments under this chapter shall be collected as fines. And as Lopez Ramirez notes, that section would seem to actually suggest that it is not a fine because it's being collected as a fine. It is two separate things. I think Lopez Ramirez, even though it's a different context, does an excellent job of showing why the council could not have possibly thought that a VVCCA assessment is a
So
fine.
counsel, if I gave my cousin a sweater and said, consider this as a gift, that wouldn't be a gift?
I mean, I think that's a very different hypothetical than what we're dealing with here. Like, if you give somebody a gift, yes, it's a gift, but
I said to consider it as a gift. My action doesn't matter. In this case, I'm taking money from someone regardless.
well, if you say something like consider it as a gift, that would seem to imply it's actually not a gift because you're saying, well, consider it to be a gift, even though it apparently is not one, right? There'd be no need to say that if it was in fact a gift. Again, I think Lopez Ramirez does an excellent job of showing why the council could not have thought, it's different context, I acknowledge, but it goes through pains of showing why an assessment is not a fine. And I think if this court were to hold that somehow Mr. TORNERO was fined here because the court gave a mandatory VVCCA assessment, that would have big ramifications for jury trials in this jurisdiction, as Lopez Ramirez notes, throughout the entire criminal code, frankly, issues that I wouldn't even be prepared to fully delineate today because it hasn't been briefed. And so I think it would be very dangerous based on a very short brief, which doesn't actually raise these issues or allude to them, to then agree with Mr. TORNERO and change the framework for how we've thought about these statutes for decades. So unless there are any further questions, we would ask that the judgment of the Superior Court be affirmed.
All right. Mr. Burgess?
Thank you, Your Honor. Just to go back to the plain meaning of the statute, I've tried to make the case that it is plain, that this is a fine, but if the court disagrees with me, the court can look at the legislative history, and I would just direct the court to the dissent in Lopez Ramirez, which describes the way that the use of the word fine speckles the legislative history. And even going back to 1981, Mayor Marion Barry proposed the legislation with a letter describing it as a fine. And then perhaps to follow up on Your Honor's previous question, when the council wanted to amend the ADW statute and impose a fine, it did so under section 223571. And the title of the chapter is Fines for Criminal Offenses. That's how you let somebody know that if they commit a crime.
Right, but that language doesn't say anything about the VVC assessments, which can be levied on top of the fine that has now been written into the ADW statute. So I'm not sure how adding in a fine in addition to the jail time penalty for the ADW offense puts anybody on more notice about the pre-existing public statutory language about the Victims of Violent Crimes Act assessment, which parties are deemed to be on notice about, that is also part of the criminal process, that they have a penalty, a sentence, which may include a fine in this case. But then we also have these other things in another part of the statute. So I don't understand clearly how adding the language of fines into the ADW statute helps your argument that your client may have been unaware of the VVC assessments.
It helps because it's put into the criminal code as opposed to some other code.
But the that's put into the criminal code here when the ADW statute was amended is an or a fine related to the ADW sentence. It's not related to the separate ADW assessment, which is in a different part of the code, and is there for all to know or see.
Are you aware, counsel, of any cases where this court or superior court was signaling to the council in some kind of way that we thought it was problematic that these were being assessed, even though that wasn't in the sentencing? Like, I don't see anything that triggers me to relate the two. And why, if the city council, in fact, did not consider this a fine, especially why the amendment would matter for this. Because they would have thought they didn't need to do that to assess the assessment.
Yes, Your Honor. So forgive me if I'm at cross purposes here. And I'm trying to answer the questions directly. The point I'm trying to make is, yes, you would not think that they are connected, if that's Your Honor's point. And so, and I take that point, but I take the point with my view that the VVCCA is a fine. So they're not connected. My client looks at one and says, I'm not going to get, nobody's coming for my pocket for this crime. And then I learn that somebody is coming from my pocket for this crime. And so that to bring back to your Honor's question, that's why it's important to, if you're going to fix, I use the council's addition of an actual fine to the ADW statute to show how it should be done clearly. And
So your argument relies on you assuming the premise, the very premise of your argument, which is that VVCCA assessments are fines. I mean, that's the only way your argument works.
yes, I'm arguing that it is a fine. Yes, Your Honor.
But the amendment to the ADW statute that I think you were suggesting to add the language about fines or to assess, to make it so that fines could be assessed as a penalty for the ADW offense. Nothing was added into the ADW statute that said, and you can also be assessed Victims of Violent Crime Act.
Yes, Your Honor. And that's, I guess the point I'm trying to make is that's right. That's why he did not have notice that he was going to get hit with the VVCCA fine from a statute that did not say anything about a fine. And I would just
How did adding the language about the fine as part of his criminal sentence and as an alternative or in addition to incarceration give you and your client notice about the VVC funds any differently than not having the fine as part of the ADW penalty did?
So my client looks at the ADW statute and sees no reference to a fine. And so has no reason to think that he's going to face a fine. I'm talking about before it was amended. And so then he's sort of blindsided by a new fine.
Right, so after it's amended, and I know he was sentenced to the old version of the statute, your argument seems to be, if the statute read as it did after it was amended, then my client would have been fine getting a period of incarceration, a fine, as well as a period of incarceration at sentencing, and then getting ready to go out the door and the court saying, but wait, we're also going to assess you under the Crime Victims Act. I kind of think based on your argument, you'd still be concerned that you didn't know that there was a VVC assessment.
Right. Not if the VVCCA combined with the VVCCA fine combined with the fine as authorized by the statute did not surpass the fine as authorized by the statute. Otherwise, we would have the problem of the VVCCA enlarging or increasing the penalty that people would face under other crimes which do impose a fine. So that
But see, I guess increasingly, I'm feeling like that what you're seeking is a legislative fix. And based on the fact that you don't think, it sounds like you think each criminal statute, ADW, armed robbery, murder, within the provisions of that statutory scheme about the penalty for that particular offense should also say, and VVCCA assessments for victims of violent crime can be imposed in addition to the fine that is allowable as a penalty along with the criminal sentencing. Is that what your argument is?
yes, I do think that is a consequence because of the principle that when people commit a crime, they should know precisely what they face. And if this was sort of a matter about conduct or if it was incarceration, I do think we would have a big problem if in a different statute, in a different section of the code, some kind of incarceration was imposed when the previous and the specific.
That was in your, I don't know that a lot of these arguments that we're now discussing further were clearly laid out in your brief.
Yes, Your Honor. I would view this as sort of a response to the government's brief. And I assume that that's allowed because there's no rule requiring a reply brief, although I could see why that would be more practical. But I do think I'm allowed to develop arguments, all of which support the claim that my client's sentence was illegal. If my brief were to have left out, perhaps that this ADW went above the penalty prescribed by the legislature, I hope I would still be able to make that argument at oral argument, even though it might not be the precise argument I made in my brief, as long as they both go to it being an illegal sentence.
Well, counsel, just to put a fine point on it, because I'm hearing kind of two different things, is your argument that you need a categorical list of all the potential monetary things someone could be subject to in each criminal sentencing section? Or was it, and I think I heard you say earlier, that something along the language of fines, something that would give a heads up to someone that they need to go look and find out where they could owe money somewhere? Is the latter enough?
I think the latter is probably the better, or I think it should be in the criminal statute, right? Where people look to find out where the penalties are that they're going to face. And if I could just make, I see my time is up, but if I could just make one more argument. When a statute creates a remedy, it implies the negation of other remedies. And that's particularly true in the context of criminal penalties. And I would say to Sutherland 24-4 for that. I think it's fair to read the absence of a fine in the criminal statute for ADW as implying a negation of the fine. That is, you're not going to be fined for this.
All right. Thank you.
Thank you.
I'd like to thank both counsel for your appearance today. And that concludes our matters. And we stand adjourned. Thank you.
All rise. This honorable court is now adjourned.